Conflicts of interest are already handcuffing SEC commissioners from ruling on many cases, and President Obama's nominee to run that agency now, Mary Jo White, could make it even harder for things to get done if she is approved by the Senate. Eamon Jabbers is in Washington to explain. Eamon?
Hiya, Bill. Well, the Wall Street Journal reported today that a raft of conflicts of interest at the SEC could make it difficult for the Wall Street watchdog to weigh in on high-profile matters, issues that some at the SEC have worked on for past employers. For example, the Journal said President Obama's SEC chair nominee, Mary Jo White, would not be able to vote on any case involving J.P. Morgan for 2 years after taking the job because J.P. Morgan was a client at a previous law firm. And Daniel Gallagher would have a conflict of interest on J.P. Morgan cases, too. He came from a law firm that helped J.P. Morgan investigate the London whale trading fiasco. Such vacancies could give the SEC the bare minimum number of commissioners needed to field a quorum on certain cases, and that could potentially weaken the commission. The SEC declined to comment to the newspaper on behalf of White, who is not yet a commission official. Back to you.
All right, thanks so much, Amy. In reaction now with attorney Andrew Stoltmann, who says this is a major problem, while Robert Heim, a former SEC official, says the benefits of having the right people far outweigh the cost of some conflicts of interest. Both join us right now for a discussion. Good to have you on the program. Robert, I think you make a good point. You want people with the experience and sort of know-how in some of these complicated cases to be working there, but how do you offset the potential for conflict of interest?
Well, that's right. Here we have a clear case where there may be conflicts, but the SEC has strong rules in place that prohibit voting on conflicts where the person directly worked on a case. But I think what's getting lost in this debate is that the SEC is a bigger program than just enforcement. They regulate the securities markets. They regulate public companies, ETFs, all sorts of market products. So to have some conflicts, I think, is going to be expected. But in order to have people that are familiar with the broader issues that the SEC addresses, we really need to have that sort of experienced voice at the SEC while still dealing appropriately with conflicts.
Andrew, you disagree. Why?
Well, I do, because I think when you have people with conflicts like Mary Jo White's going to have, I think what you've done is you have, in effect, guaranteed institutional paralysis and institutional gridlock. You know, you look at somebody like Mary Jo White, and a crucial enforcement action may be taken against J.P. Morgan for the London whale debacle. And if you can't have the SEC chairman weighing in and deciding whether that should or shouldn't take place, I think that's a big, big problem.
What about that, Robert?
Well, the SEC enforcement program is much bigger than just the chairwoman or any commissioner. There's a staff of people at the SEC that worked on these cases and that developed them over months and months. So whether or not the chairwoman is conflicted in one particular case is really not going to be a determinative issue. There's really been no evidence that any enforcement activity has been slowed down as a result of any conflicts that the commissioners may have had with past employers. And I think the staff and the senior people there are more than capable of moving these cases forward with or without the votes of any one given commissioner.
But Bill, I think the problem with that is, in effect, we are approving an SEC chairman, or in this case, chairwoman, because we want her to partially make decisions on what goes forward. I understand leaving decisions with the staff, but ultimately it comes down on the shoulders of the commissioners. And if they're too conflicted with too many cases, that's a big, big problem.
Yeah, but you know, Andrew, you really can't have it both ways, right? I mean, one of the big issues that we saw when the financial collapse occurred was the fact that nobody knew anything about some of these complex derivative instruments because they didn't have the experience, they didn't have the know-how. So you can't have a commissioner that actually has the experience and then say, well, that's too much experience and it's a conflict of interest. So how do you fix this issue then?
Well, Maria, I think that's a real good point. Clearly, you do need people with experience, but I think the big problem is what we've seen now is we've seen commissioners who are former SEC defense lawyers, and that's where the problem starts. You know, if you have someone like Mary Jo White or Harvey Pitt who used to defend Merrill Lynch, and you're now expecting them to make decisions that impact their ex-clients, clearly they can't do that. So you can strike a balance. You can have somebody with experience. For example, a state regulator.
They should be able to do it, shouldn't they? I mean, they are fighting for the law, so they should be able to do it. They should be able to recognize right from wrong.
Well,
just because they defended a firm on Wall Street doesn't mean that they're lying.
No, Maria, but very clearly, if your ex-client has paid you hundreds of thousands of dollars to defend it in the past, I think it's going to be really problematic for that person to be objective on the decision.
Certainly we don't question the integrity of a Mary Jo White, but at least, Robert, you have to say that the optics are not great if you have a person who is chairing the agency who has those kinds of conflicts, especially, as Andrew points out, if it comes to a very high-profile case that the SEC is trying to enforce on.
Well, I think the problem with the analysis is really just focusing on one small aspect of Mary Jo White's career. Remember, before she was a defense lawyer at a Wall Street law firm, she had a very distinguished career as a federal prosecutor right here in New York City, where she took on some major cases against Wall Street interests. So I think President Obama's pick of Mary Jo White really was based on her proven track record as a senior federal prosecutor and her ability to get tough settlements from Wall Street, and weighing that against her potential conflicts from representing certain Wall Street firms. I think it's a small price to pay, and the SEC does have policies and procedures in place to deal with conflicts, but it shouldn't disqualify a person of Mary Jo White's caliber from serving as a chairwoman.
Yeah, that's a great point.
But Bill, I think you hit the nail on the head. It is an optics sort of issue, and the SEC is trying to get a new reputation after missing Bernie Madoff and Alan Stanford. They're trying to create a new SEC, and when you have the chairperson not being able to take part in crucial enforcement actions, at a minimum, the optics are horrific.
All right, well, we will see what happens. Thank you, gentlemen, for your thoughts on this.